Yes.
We are here with Advocate Mathews J Nedumpara. He is a senior advocate and he is known for taking up public causes that have great importance to the public. He has recently taken up causes which relate to judicial reforms, to reforms within the judiciary, the way judiciary conducts itself, the way the organization of judiciary works for the common man. So he ended up being convicted of contempt of court on 12th March, just a few days ago. And this is something that the common man should know about. So I would like to request Advocate Mathews to tell us in his own words what exactly happened. What is the significance of the cause? What is the significance of this whole event?
Yes. Thank you. It is true that I am convicted of contempt of court in the face of the court by the Honorable Justice Rohington and Justice Vineet Saran. As you read in probably in newspapers, the trigger point was in the course of the arguments. As these arguments flowed, I happened to invoke the name of Fali Nariman, the legendary living legend, the father of Rohington Nariman. The case which I was arguing, or I was representing, the National Lawyers Campaign for Judicial Transparency and Reforms, NLC, of which I am the president. The NLC is an association of the first generation lawyers. The legal profession, 95% of the lawyers belongs to the first generation. But practically the 95% ordinary lawyers, they have little say in the system. 5% of with the apology I used the word elite class lawyers. The sons and daughters, nephews, daughters are not many, the sons and brothers, nephews, etc. of the sitting and retired judges, senior lawyers, and powerful politicians, ministers, even very senior bureaucrats, and celebrities and super celebrities. They actually dominate the bar. The bar and the bench. The bar, in the sense, you have heard about that, we have senior lawyers and others. In other professions, we have got senior doctors. In chartered accountants, we have fellows, fellow of the Institute of Chartered Accountants of India. In the case of company secretaries, we have got a similar description, fellow and associate member. And there, the fellowship is given based on the seniority. I believe many other professions the same thing exists. But in the senior designation, see, my friend has, out of his regard for me, called me a senior lawyer. I am in the profession for 35 years. I have crossed 60. Still, as per the Supreme Court rules, I am a junior lawyer. And lawyers who are maybe 15 years or 20 years younger, they are the brother of a sitting Supreme Court judge, or retired Supreme Court judge, or son, daughter, all. They are elevated as senior to a case. And this designation of lawyers is always considered to be not a fair one. It is always considered to be favoritism, nepotism. So the word nepotism comes from where? It's come from the Catholic Church. Even popes used to appoint their nephews and all as popes or senior positions in the ecclesiastical hierarchy. So this happens in the judiciary. So I believe it may be impossible to find a lawyer who has crossed the age of 45, who is a son of a sitting judge or son of a retired judge or immediate brother or relative to continue his practice as an ordinary lawyer. Either he is elevated at the age of 40, 42 as a judge, or he, in the alternative, is elevated, designated as a senior lawyer. So, therefore, it's a reality, it's a sad truth that majority of the judges of the superior higher judiciary, so to the of the senior lawyers, belongs to the elite class of lawyers, and judges. The reason for this grievance is judges select judges. It is not because the Constitution provides so. Constitution says the President shall, in consultation with the Chief Justice of the India and the Chief Justice of the state concerned, so to the Governor of the state concerned, shall by warrant appoint a judge of the High Court. Therefore, the power of, in consultation, the President, the executive government is the consultor and appointing authority. The consultee is the Chief Justice. So the decision is always left to the consultant. Suppose I am a lawyer, you come to me, consult something. And I am only a consultee. You give my opinion, decision is yours. Then in S.P. Gupta's case, the Supreme Court held, 7-judge constitutional bench, 4:3 held. Consultation means an effective consultation, but does not mean the primacy of the views of the Chief Justice of India. Then this issue was again in...
Sir, if I may interrupt you.
Yes.
What was the subject of the writ petition?
Yes.
In which you were held for contempt of court?
That is about senior designation. Senior designation.
Can you explain that matter?
Yes, coming to that, because senior designation issue and the designation appointment of judges are closely related. Yes. I will not elaborate much into the appointment of judges. So that judgment was reviewed by a bench of 9 judges and held that consultation doesn't mean mere consultation. The opinion of the Chief Justice of India, and that opinion which is found in the form of an opinion of the collegium, that will prevail. And that decision is not judicially reviewable. And in a sense, the judges to case brought in the system of appointment of judges, and the literally meant a scenario where the judges appoint themselves. And I said, judges under the section 16 of the Advocates Act, the High Courts and Supreme Court can designate lawyers as senior lawyers. So the judges only designate senior lawyers. Judges only appoint themselves. So the peer judges of the collegium appoints the peer judges of the Supreme Court. And therefore, the system where judges and the senior lawyers both are appointed or selected by the judges themselves.
So it turns into a kind of an oligopoly.
This is, I don't want to use any strong words. That word oligarchy was used by Justice Krishnaiyer. So therefore, the National Lawyers Campaign find, we have statistics before us, that there is hardly any representation of the ordinary class of lawyers in the higher judiciary. See, I should not be misunderstood as somebody who is blindly criticizing the system. No, never. As I said, I repeat, I spent almost a lifetime in the legal profession. What I do is for the betterment of the institution of judiciary. And therefore, there are certain deficiencies which I have noticed. And I believe my role as a lawyer is to do what best I could to improve the system. And now...
So just from the point of view of the common man,
yes,
and to bring in a couple of perspectives as a common man, which I bring in.
Yes.
First of all, senior advocates and senior counsels are extremely powerful people and will usually get orders in their favor much more than an ordinary lawyer or a junior advocate. That is one aspect of it.
Yes.
The second aspect is the earnings of a senior advocate or a senior counsel run into lakhs of rupees, like 10 lakhs, 15 lakhs. These are the kind of figures we hear per hearing, per appearance. So a senior counsel earns the entire annual salary of a judge for a single appearance. These are some of the things we hear. and so being bestowed with the title of senior advocate means endowing them with huge earning capacity as well as the power to influence the course of judiciary. Is that not correct?
No. See, what you talked about is the perception. No, I will not. I will not go much into that aspect. It's a perception. See, I will give a slightly different twist to what you have said. See, when we National Lawyers Campaign seek bring an abolition of the system, collegium system of appointment, so to the designation of the lawyers, which we consider to be totally unnecessary. The point I have in mind is more about the concern for the litigant public. See, by the senior designation system, leads to denial of justice to the common man. The court's a reality. That's why we asked for video recording of the court proceeding. We fought a long battle for that. The courts is a perception. And I say with utmost respect to the institution, the judiciary, I would say, that perception has much truth in it. The courts seriously take, and listen, here are majority of the judges. I'm not saying there are not exceptions. Only designated lawyers. And the designated lawyer, he whose brief he is arguing the brief of rich people, rich, super rich. So therefore, the cases, the system, the malaise of the system of senior designation is, a case is taken seriously, not necessarily because of its importance in terms of the human rights violation or the rights involved,
the merits
of the case, but who is appearing. So see, I would say Ratan Tata could go to the Supreme Court and say that the radio type, the radio tape, yes, Nira radio tapes affects his privacy or is defamed. The petition was admitted that circulation of that tape has been banned. So that on the contrary, see how many petitions are entertained in the Supreme Court in a year? Maybe less than 100. How many people? Hardly 1,000 petitions are filed in a year. So therefore, ordinarily, can I go to the Supreme Court complaining that? So Ratan Tata could go to the Supreme Court. He himself is a heavyweight and he is represented by a big lawyer.
Yeah, a common man could not imagine going to Supreme Court and getting that kind of relief.
Common man, I'm sorry if I'm mistaken, common man he's denied justice. See, in a system you need a good lawyer, to get justice. See, merits of the case, unless you are able to get a good case, to get an order to succeed in a court, assuming that you have an excellent case, you need a good draftsman, somebody you need to write your case. You need an arguing counsel who can put across the facts properly. Put across the facts, present the facts properly. You need a good judge. So, therefore, the most important factor is a lawyer. So, our system of legal education is so poor. And the first generation lawyers who are academically brilliant, they don't get any encouragement. And they leave the profession, they work in somewhere else, in some company as in-house lawyer. And many talented people get, they're frustrated, disgruntled. They get disgruntled because, see, people who have come out in the colleges as first rank holders, I can give any number of names.
So instead of becoming a meritocracy, it becomes an oligarchy.
So, see, your success in the legal profession depends on the connections you have. If you are a son of a former Chief Justice of India, or a Chief Justice of High Court, or a senior lawyer, your life is much, much easy. If you're a first generation lawyer and you come from humble backgrounds, say for instance, I'm a school teacher's son. So, life is extremely difficult. Extremely difficult. So, therefore, I'm focusing on two aspects. First, I would say, for me, the rise of the lawyers is only secondary. Because when you came, you saw the kind of how many
people.
Yes, so many slumlords came to me. So for me, the ordinary man, the slum dweller, the poor litigant, their concern is the primary. So the senior designation system deprive the common man, the poor litigant, access to justice.
You're talking about the stakeholders.
Yes, stakeholder. Lawyers come secondary. Institutional judiciary is not for lawyers and judges. They are certainly is an important factor, important constituent of the institutional judiciary. But judiciary primarily stands for the people. The real stakeholders are the people. So my contention is the system of senior designation is absolutely unnecessary. It serves no usable purpose. It categorizes lawyers into two. It brings in some kind of an apartheid and deny great amount of injustice to the first generation lawyers and denied in absolute terms justice to the ordinary poor litigant. So therefore, we National Lawyers Campaign filed a petition to the Delhi High Court. Then, with the utmost respect to Mrs. Indira Jai Singh, she filed a petition to the Delhi High Court. Her grievance is that some of her friends, it seems to me, who are unable to, out of their poverty, ignorance, illiteracy, were unable to approach the Supreme Court. So she acting pro bono, filed a petition for them and said the system of designation needs, transparency. If the system of designation is fundamentally sound and it is required to be retained, then further transparency, we are in agreement with her. But our contention is, it is absolutely unnecessary. It is pernicious.
Where is the need to distinguish between senior and junior?
Scrap it. Yeah. Therefore, we filed a petition to the Delhi High Court. But since
so the content of your petition was different from the Indira Jai Singh.
Absolutely.
Indira Jai Singh, just to clarify, wants transparency for the system, but she wants the system to continue.
Indira Jai Singh to say that she filed a PA means where you file a PA where the person aggrieved is unable to approach the court out of his poverty, illiteracy, ignorance or other deficiencies. And I do not know, a person who is deserving to be designated as a senior lawyer could be facing such difficulties. But that is the premise. If she filed a PAL.
But the relief sought, just to clarify, the relief sought were entirely different. The relief that that PIL sought was that the system should continue of distinguishing senior advocates, naming senior advocates should continue, but the selection should be done in a transparent manner.
Exactly, I put it very rightly.
And so you are saying it should not be there at all. Abolish the system. Yes. That is the National Lawyers Campaign.
Yeah. And when the writ petition came, see, we were not actually heard. The Indira Jai Singh was heard. Supreme Court Bar Association President was heard, and then the Bar Association of India was heard. They all said, we are not questioning the system. We are only wanting some kind of a transparency in the system. So, and our plea, that validity of the section, and particularly look at the specific plea, that to call a lawyer who has been in the bar for 40 years, 50 years, still a junior, it is derogatory, is inhuman, and it affects their dignity. That issue was not considered. The validity of section 16.2 and 23.5 was not really considered, and it only looked from the point of view of the lawyers, and there was no litigant public was there. This real stakeholder, the common man, the poor litigant, there was nobody to portray his or argue for his cause.
That's stakeholder.
Yes, that's stakeholder. And therefore we filed a second petition. And Mr. Sunil Gupta is an activist. He has been associated with us in a big way. He is an office bearer of the campaign for Home for All. And the campaign for Home for All is a cause. We are fighting for the cause of the slum dwellers whose families were demolished, were rendered homeless in the execution of the implementation of the High Court's order acting on PILs. So that I have dealt with earlier also. So therefore, this petition had a different, the cause of action was different, the parties were different,
prayers and
the prayers were different, the entire different perspective. So we said, we said, this petition is not barred by the doctrine of res judicata. So res judicata is a Latin word, means the party, res judicata means judicial decision, right or wrong, is final and binding between the parties. So we said the cause of action is different, the parties are different, therefore the earlier judgment is not binding. Secondly, the concept of precedent, that is, you call Article 141 of the Constitution. The law declared by the Supreme Court is binding on all courts and tribunals. As a precedent, what is a precedent? If a court, while adjudicating a case, evolves a principle for the resolution of the case which was before the court, the reason for that principle, that the rationale decisis, reason for that principle, it will be applicable in future cases as a stare decisis. That is stand by the settled principle. So here we say there is no principle which was evolved in the Indira Jaising's case which could be applied here. So this case is entitled to be heard on its merits. And we were aware of the practical realities. So though we challenge the validity of section 16.2 and 23.5, in the course of the arguments, I wanted to give greater focus to the issue that, yes, if designation system is to be continued at least for this time being and not to be revisited now, then designate all lawyers who have put in a practice of 35 years, 32 years and been in the bar and been across the age of 62, as we have done with the High Court judges. So Supreme Court designated 25 retired High Court judges. So we say that the bench and the bar are the two wheels of the same chariot of justice, and therefore the lawyers, the practice, the service as a lawyer and service as a judge are comparable and should be treated equally. And this is our plea. It's up to the court to accept it or reject it.
So did they hear it properly?
No. When I started the arguments, I made a grievance that in the collegium system, in the current system of designation where judges designate lawyers as senior to case, it is mostly the kith and kin of judges, senior lawyers have been designated. And this is not a bald statement. We have absolute statistics with us. If somebody could point out at least 5 lawyers, first generation lawyers, which the Supreme Court has designated in his history of 70 years history, probably I will withdraw my statement. So the vast majority of the lawyers designated by the Supreme Court since independence is immediate relatives of the judges, senior lawyers, and nobody else.
So being an immediate relative of judges and senior lawyers endows an automatic advantage. At least on the face of it, it gives an automatic advantage while being designated as a senior advocate, which others do not enjoy.
Look here, you come to Bombay High Court. I've seen, this is a very extremely painful thing. A lawyer friend of mine, DRT lawyer, he has been of my age. When he argues a case in the High Court, in the DRT, when he comes to the High Court, he engages a lawyer just this age of his son. I am not naming the lawyer, naming the judge. Why? He is a son of a sitting judge. He is just 28. Because the perception, or because he believes he will get an order. If he appears, he will not get an order. So that is the scenario in many places, many high courts. All orders are discretionary. See, in the final hearing matter, the question of senior, the kith and kin, etc. has little importance. But final hearing, see, your success as a lawyer depends on your ability to get the interim injunction. Reliefs. Whether you are able to get a stay, whether you are able to get a bail. These are all matters.
And sometimes on the strength of the orders, the merits can fall by the wayside. It is just
I am not going to make any comment on that. So all that I say is, therefore, the ability to secure a favorable interim order to protect the interest of your client it determines your success in the profession. So therefore, that is quite easy for the sons, immediate relatives of the judges, or at least that is the perception. And the perception is, yes, senior lawyer, yes, senior designation considered as the cloud or the kind of acceptability you have with the judges. So therefore, this, according to us, leads to discrimination of the ordinary litigant, so to the ordinary lawyer.
There's also the phenomenon called uncle judges.
No, I don't want to use any harsh words. No, I don't want to use anything harsh words. So all that, therefore, this is an issue, and therefore, and then what my focus was, yes, at least lawyers who have crossed the age of 62, been in the bar for 35 years, and if they are desirous to be appointed or some reference is made, then consider them also to be designated. While we say that designation system should completely be abolished, but the court has taken a decision in the very recent past. So it is not it is not reasonable for us to think that immediately the plea of total abolition would be accepted. And in the judgment which was ordered by, I believe, Justice Ranjan Gogoi, the current Chief Justice of India, His Lordship was pleased to make it clear that these are to be revisited after some time, when the system which as it's put to work, when you find out notice the deficiency. Now, then the Fali Nariman, the living legend, we all have great amount of respect for him, and there are areas we completely disagree with him. As I told you about the challenge on the NJAC. I believe that is a great. It is most unfortunate. NJAC means the Constitution 99 by the Parliament by enacting the Constitution 99th Amendment Act. So to NJAC Act, which has received the assent, not the
judicial accountability.
Yeah, no. National Judicial Appointments Commission. So the Constitution was amended, which received the assent of both houses of Parliament, unanimous except for Ramjit Padani, and received the ratification of the majority of the state. And there's a further enactment called National Judicial Appointments Commission Act, and this Constitution Amendment and the Act contemplate the constitution of a Judicial Appointments Commission, NJAC, and the constitution of the commission is headed by the Chief Justice of India, yes, and the two senior-most judges of the Supreme Court as the members, and there are two eminent persons to be selected by a committee consisting of the Honorable Chief Justice, the Prime Minister, and the Leader of the Opposition, and the Law Minister is the ex officio member. And then if two members disagree, nobody can be appointed. I find it's a perfect composition. And if tomorrow the actual experience reveals some deficiency, then there's time to revisit. But there is nothing which could be, there was no reason why one could have attacked the commission and an independent judicial commission. And I believe the commission would have gone for advertisement or notification of vacancies, invitation of applications from all eligible candidates, so to references from all stakeholders, a proper screening, and a transparent, objective selection. That is what.
So it would have been a better alternative, more transparent alternative to collegium
system. In all humility, I believe it would have made an enormous difference. And the grievance that the first generation lawyers and other deserving are not given a due opportunity would have come to an end. See, as you said, justice should not only be done, but should seemingly and manifestly be done. Perception. So today the perception is the collegium appoint, the judges appoint themselves, and the collegium has picked up the kith and kin. The allegation of nepotism, favoritism, it is not Mathews J alone who is saying that. There is literally unanimity about it. Even Justice Kurian Joseph, His Lordship said, yes, the hour is prehistoric and glasnost. But therefore, this is what was the controversy. And when in the course of the arguments, I just wanted to say that even Fali Nariman, the living legend, the undoubted doyen of the bar, support our plea that if the only matter that could be reckoned is should be reckoned is the seniority based on the length of seniority based on the date of enrollment and nothing else. So the seniority reckoned from the date of enrollment. This is what I wanted to say. When I ventured to in the flow of the argument, I said Fali Nariman, even Fali Nariman, His Lordship Justice Rohington Nariman was trying to be very angry.
He is his son.
His son, yes. Then Lordship asked, why did you take out the name of Fali Nariman? Then I was taken aback and I was shocked, shaken. And I said, did I say anything? I asked to the other side and said, did I say anything? Then His Lordship said, yes, you took the name of the Nariman. And then His Lordship said, all the lawyers here, they will give affidavit. And some of the lawyers said, yes, you took the name. Then immediately sought the apology. I said, I'm sorry, I apologize. And then I wanted to say, all that I wanted to say was, then Your Lordship was interrupting. Still I wanted to say, I went on to say, said, what that I wanted to say was, that even Fali Nariman support our plea that what matters, the only thing that relevant is the seniority reckoned from the date of enrollment and nothing else. And I can in all honesty say, this issue I had personally discussed with the legend Fali Nariman, and and Fali Nariman has told me. So therefore, this is his view, and I believe that view is fairly known to the legal fraternity. So therefore, it happened to there to be some misunderstanding.
So Justice Rohington Nariman took it as a personal affront that you named his father. Is that it?
No, so I don't want to use any such
ordinary man.
No, I don't want to use any such. That's all in the realm of inference.
He seems to have felt offended. That's what the judgment seems to say something along those lines.
Rohington Nariman, he's a sitting judge of the Supreme Court of India. I respect him, not only the chair, I respect him, the person both. So whatever I say, I have to be very careful about the words I use. There is reticence or moderation that is sacrosanct, and therefore I have to be very careful about what I say. I would only say, but at the same time, whether I plead guilty of not mincing words, and a lot of people probably would have been dislike me, hate me, because I talk very unpleasant things, sometimes even on their face. I tell you.
So what is the fate of the writ?
So therefore the reason is, we filed a petition in the Delhi High Court for a declaration that the explanation to Rule 6 or the Bar Council rules, which says the court means not the entire court, but the particular court where the relative of a judge, as a relative of a lawyer is a judge. That is what we challenge. So the Bar Council rules prohibit a lawyer from practicing in a court where his immediate relative is a judge, and the immediate relatives have been defined. So the Rohington Nariman, when his lordship was appointed as a judge, we were all so happy that we want very competent people in the Supreme Court, and we are all so happy. We celebrated that. Even we have been asking for, don't see in appointments, only thing that matters is the merit. We need erudite men of reputation, competence, of course the other considerations like regional representation or minority representation, all these have to be women's representation, all that are relevant, but still the predominant factor ought to be merit. So we were so happy. But when Fali Nariman started to continue to practice, I wrote a letter, and that letter is also.
He should have retired. Is it?
No. See, the question is, I wrote when Justice Krishnaiyer was elevated to the Supreme Court, his sons left the legal profession. See, nobody can ever think of a man who has a greater reputation of impartiality, independence, and courage, and commitment to the cause of justice and the cause of common people than Krishnaiyer. But the perception is important. So Krishnayer's children left the legal profession.
Caesar's wife should
be. Yeah. See, I'm not wanting to use such a strong expression. That is, Caesar's wife should be above suspicion. Those are strong statements. I don't want to use such strong statements. See, when Justice, I'm from Kerala, so the Justice, Shivashankara Panikar, His Advocate General is a great lawyer, and probably, when I enrolled in 84, I started practice in Kerala High Court. Shivashankar Panikkar was the doyen, the most respected lawyer, a very handsome, very gracious man. Then his son, K.S. Radhakrishnan, was elevated to in the Kerala High Court, maybe in the year 1993. In fact, it happened after a short while after I had appeared in a case where Justice Radhakrishnan was representing the State Bank of India, I believe. Yes, and I was for the Reserve Bank of India. Then, the moment Justice Radhakrishnan was elevated, his father, he was a doyen, number one, the same position as Fali Nariman, the Nariman is today. He left the legal profession. And I can cite many examples. Therefore, this is an issue.
So this became a sore point. You had earlier already written a letter to Mr. Fali Nariman, asking him to retire, congratulating him on the elevation of his son as a judge, but asking him to retire.
No, we did. So the letter is that we use a very sophisticated language, very, very sophisticated language. See, lawyers' language should be like the first appearance of a princess, French princess. That is called it ought to be so elegant, returned. So it ought to be. So lawyers' language should be very polite, very sophisticated. So therefore, I wrote a letter and bringing this issue to the notice of Fali Nariman. The real reason is, in fact, I don't know, this issue about in Bombay High Court, a sitting judge's son is practicing, and there are a lot of, it is almost, with due respect and with the hesitation, I say it is almost amounting to a scandal. So I addressed a letter, and that letter made that particular judge, my sworn enemy. Though I have all the respect and regard and nothing against him. That where I said in my letter, I said your lordships is so erudite, highly respected, and your son's practicing here leads to some kind of a damage to your lordship's reputation, even to yourself, and therefore your lordships, this is what the 7th Constitutional Bench in S.P. Gupta said. The judges should want India themselves to move out of their own state to go to some other state, and so that they don't give room for any kind of complaints and grievances. So that is very important.
So this was a cause which you had been speaking of.
So therefore, then the reason he told me, if Fali Nariman is practicing in the Supreme Court, then why you take up those issues? So that is the reason. So therefore, I certainly say National Lawyers Campaign is a campaign which I lead. But don't think that I am the only person. Every decision is taken by me. We used to have general body meetings every week. Now the frequency has come down. But collective decisions are collective. And then we decided to file this petition in the Delhi High Court. And then, fine, we are, instead of filing in the name of the juniors and all, and you appear as a lawyer, then I said, fine, if I am filing a petition and we are naming the Fali Nariman as a respondent, then I myself should be a petitioner. That is how I filed the petition. And this petition maybe have been filed in Delhi. Matters are taken care of my friend, associate.
This is a separate petition?
Separate petition, where the issue, the attack is on the explanation of the Rule 6 of the Bar Council rules. Then notice, in Delhi High Court, if you file a petition, notice has to be given to the respondent. So the notice was given to living legend Fali Nariman. So after the notice was said, but before the case was to be listed for hearing, which was to happen on the very next day, this case the seniority issue came to be listed before Justice Nariman. Then I always had the greatest regard and respect for both his honorable Rohington Nariman, so to Fali Nariman. And therefore, I always find I never use the word Nariman sir or Honorable Nariman sir or Honorable Nariman. I always say Nariman. See, people say, sometimes an objection was taken. See, when you reach us, you become such a celebrity, then Sri or Sir, nothing is required. You see,
Amitabh Bachchan is Amitabh Bachchan.
Amitabh Bachchan is Narendra Modi is Modi.
He's not Sri Amitabh Ji Bachchan.
Nothing, nobody will say. Donald Trump is Donald Trump. I tell you a classic example. In Malayalam, see, in my childhood, Devame ni Valivanavum. In Hindi translation will be God tu Mahane. So somebody recently the later it was changed. Somebody thought to call God tu ni, that is tu, is disrespectful. So now they change it. Devame ang Valivanavum. So that is the same thing about Supreme Court. Most lawyers write the Honorable Supreme Court. It is wrong. The Supreme Court is supreme. When you call the Supreme Court, no honorable is required. So calling Fali Nariman as Nariman is not disrespect. If I meet him and say Nariman, that is wrong. When I go sir, yes. When I address in the public forum, then it say Mananiya Sri Nariman. So Fali Nariman is, that's what we use it. And if that is wrong, I apologize.
Justice Nariman felt offended because you referred to him as Fali Nariman and just... Is that the offense? I mean,
no, same.
For that you have been...
I see, this all, see in the flow, you are talking. See, we are human beings. And I certainly, I am as fallible as anyone else. In the course of the argument, and see, I said, I am the bar for 35 years. This life has spent, my lifetime has been literally been spent. This is my home. I am an insider. I am not an outsider. I have no agenda to destroy it. My only agenda is to do what little I can for the betterment of the brother lawyers and the poor litigants. Many people mistake me as not many people, the senior lawyers or the dynasty, those who they treat me as an alien enemy, but I don't treat them as any enemy. So therefore, court for me is my home. Therefore, I am tempted to argue a matter without much of a stress or something easy. So then, when even Sri Nariman must probably have said so Fali Nariman, then his lordship took objection. Then I was shaken. Did I say anything wrong? Then this has all happened, and maybe because I do not know, maybe I believe.
Is this the root cause of the contempt?
I believe because see, judges are also human beings. I may be more fallible than them, but we as judges are also human beings. They are all also, as fallible as we common people. See, therefore, maybe if I filed a petition against Fali Nariman, probably would have hurt his lordships. So
what is the judgment saying? Actually, more critically now.
So therefore, the all issue was triggered of my use of the word took the name of Fali Nariman, and see, in retrospect, I believe it was absolutely it was a great error, bona fide error. I should have been careful. I should all have referred to Fali Nariman. I could have said that even the Dian of this bar, without directly naming him, consider that seniority has to be the only factor to be counted is the seniority from the date of endowment and nothing else. Therefore, there I made a mistake, and immediately I apologized. And thereafter, I wrote a letter. Then I came to know about the issuance of contempt, convicting me of contempt from the social media. And see, this is something which I immediately apologized. And I have, I'm willing to apologize.
Summarily, but is this the reason for which you have been held in contempt? Is the contempt, because what is the judgment saying?
Say the judgment, in the judgment, there are only, the judgment is running into maybe 32 pages or something, but only
what are the key elements of
two
this
paragraph
contempt?
is the issue is what happened in the face of the court is dealt with only two paragraphs. One is the reference is that I said I allege that judges of this court are only unfit to designate seniors as senior advocates. I did not say so.
You did not say wholly unfit.
No, I didn't ever. I don't use such expressions at all. All that I said, judges appoint designating lawyers immense the independence of the bar. That independence of the bar. See, if judges were to be appoint lawyers, designate as lawyers, then a lawyer loses his independence. So people like me will never be designated. Assuming that, I'm not saying that I'm eligible or deserving, nothing of the sort I'm saying. Assuming that an outspoken lawyer would ever be designated. So independence of the bar, that is an issue. Then when a lordship said you are committed contempt, then I said, then I quoted a Latin maxim. That less it is tolerare vult, privatem damnum, quam publicam madam. That I said the lawyers like judges, not merely lawyers and judges, even the parties to the proceedings, so to witness, all are entitled to immunity. Because institution, court doesn't mean the judge alone. Court means the lawyer, the parties, witness, everybody. So therefore
so it's the immunity which is resembling the immunity of an MP.
Yes, parliamentarians. Yes. So what is the meaning of the maxim? Lex etius tolerare vult, privatem damnum quam publicam malum. Law will tolerate private injury for what? Publicam malum. The benefit of the malum means fruit. For the public benefit, law will tolerate private injury. So therefore, the immunity, I said the lawyer should have as much freedom to present their case, fearless of the judge. Fearless of the judge is an important issue. Fearless of the society at large. Fearless of the litigant who may
speak without fear or favor.
He may stab you in the back. And I believe that I quoted Lord Bardam, where the lawyer's duty even extends to putting the country into peril. So suppose I had to appear for a terrorist. For instance, what was it, the terrorist name?
Ajmal
Kasab. Then, in defending him, the sacred duty, I may be called upon to even the interest of the country in peril. So, see, I'm not...
I get it. It's an extreme position.
I'm not saying that one should go to the extreme position. But all that I wanted to say that lawyers should have the freedom
to defend.
Yes, and the word from the mouth says, you are humans. See, even the allegations against me is that I took the name of Fali Nariman. And when asked why did you take the Nariman's name, and then I denied having taken the name. So assume that assume this to be truth for mere argument's sake. Then taking out a name by mistake and denying having mentioned, it cannot be. It is a mistake.
You did not insult him. You mentioned him.
No, see, how can I ever insult him? I have always greatest of regard for him. You look at my library here. All books are him. I have read all books. Recently, the book where the Nariman's book, Lord said the Honorable Supreme Court. That book, I read it, and to continue the reading, I took it to the court. It's lost somewhere. So when I was a young lawyer, when Fali Nariman used to come to Kerala, particularly for church case, etc., we were all there talking to hear his arguments. So he is. See, Lion of the bar, we all respect him. That doesn't mean that there cannot be any difference of opinion. There are difference of opinion. And the first and foremost opinion is the collegium system. The judges to case, I would say with utmost respect, Fali Nariman was the largest and instrumental in bringing the collegium system. The parliament, which I consider the will of the people, then wanted to dismantle it, substitute with the NJAC. Then the NJAC case, it was Fali Nariman who took the leadership. and that act was, the constitutional amendment was quashed. So therefore,
there are some differences of opinion.
Yes, we say that the current system, look at these are facts you deny if you can. I have the greatest of regards and respect for all the past Chief Justices and the future Chief Justices. I hold them privately in great esteem. In fact, I could say Chief Justice Thakur is such a noble man. After his retirement, I went to him and met him. But all the past Chief Justices, many of the past Chief Justices, Thakur, then Justice Lotha, then the Deepak Mishra, then the future Chief Justices, all. Now Justice Khanna, I would say Justice Khanna is the illustrious nephew of H.R. Khanna. So they are all very meritorious, deserving, erudite, upright judges, including Justice Dr. Y.V. Dhananjay Chandrachud. But in a system,
but they are children of other judges.
But if a system, all the future Chief Justices and the past Chief Justices is drawn from a narrow
spectrum of society,
narrow pool of the media, the pool of the sons and daughters of the former judges and lawyers, etc. Then that leads to a perceptional difference. That will lead to a situation. Many ordinary lawyers think that what do we have any relevance or role or a say in the system, in the administration of justice. That's an issue to be addressed. I am only raising it. I may be wrong.
There was one more issue. I think something about a phone call and contempt. And this seems like an unrelated issue in the same contempt judgment.
Yeah, same. I would quote a Latin maxim, but many people don't understand. It's a fundamental principle that the judge only knows things which are judicially known to him. A judge doesn't know anything other than that is judicially known to him. So a judge, while considering a case, can only consider the matters which are brought to him in a judicial way. He cannot
come in with knowledge from outside and say,
he cannot collect information from outside or employ his own personal information. So therefore, that is one of the fundamental principles of law. With utmost respect, this judgment literally is about my past, but the past incidents or about me. And there are they say the allegations that I have taken that the allegations that I browbeat the judges, then allegations that I take up the case of hopeless clients, hopeless causes, that the debtors bring me, they engage me when there is someone or other to put off the auction. And then the allegation that I have raised the issue of maintainability. Then another issue that there's a ruckus was created in the DRT.
Which is not relevant to the writ.
No, there two things. One, which is nowhere relevant. These are all matters which are pending in the High Court or the Additional Metropolitan Magistrate Court. These are pending matters. And the concept is, a matter which is before the High Court or before a magistrate, it is in the exclusive domain of the judge concerned, and they alone can decide it. And nobody has a right to no courts will go into those issues. Then let me go into other aspect. The allegation that yes, I complained that I was not heard, I was ill-treated. That is
also taken as contempt?
Yes, that is taken as contempt. And I appear for clients to allow them to wriggle out of the undertakings.
That's not contempt.
Then, yes, I was a party for the litigants to make wild allegations against judges. Yes. Then, all these things are not in the realm of opinions. There's a difference between facts and opinions. But there is only one thing which is like black and white fact. That is a case of impersonation of a noble judge of the member of High Court, Justice Vasifdar, the former Chief Justice of Punjab and Haryana High Court.
You are accused of impersonating.
I am accused of impersonating Justice Vasifdar. And who made the accusation? My friend, Dr. Virendra Saraf, who is currently a secretary and is a very powerful lawyer in Bombay. He is a son of a former Chief Justice. He made an accusation in the open court. I impersonated Justice Vasifdar. Then, to supplement it, he filed an affidavit through his client. Call records were called for. Vodafone, Ideal, Cellular, all called for. And the Chief Justice, and I also got the call records. Court also provided me the call records, which was provided by the service provider, and I had the call records obtained from the Vodafone. And the call records revealed that I did not call at all.
You are accused of calling Mr. Saraf.
I am accused of calling Mr. Saraf as Pratap's clients from my phone number 9820535428, and the fact is I did not call at all.
So they accuse you of saying you are Justice Vasifdar.
Yes.
From calling from your phone.
Yes.
And saying that Mr. Mathews is sitting in front of you.
Yes.
And then
ask your client to call me. Yes. Ask your lawyer to call me. Right. So
but you have not placed the call at all. In fact, you have received the call. Is it?
I received 2 calls from Dr. Saraf's client, which lasted for 16 and 26 seconds, and I did not call at all. These call records were before the Chief Justice, then Chief Justice Mathews Shah, and the court was crowded. That is the reason. This incident made me fight for the video recording of the court proceedings. The crowded courtroom, it was minimum 100 lawyers. The representatives of Vodafone, everybody was there. And I, with all command or the energy I could command, with all advocacy I could muster, I repeatedly said, my lords, I did not call at all. I did not call at all. It is on the contrary, the Saraf's client who had called me twice.
And its record is showing it.
Look at the records. If I had not called, how come that I impersonate Justice Vasifdar? And the call record shows that it is Dr. Saraf's client who had called me.
And there's no phone recording, right? There's no phone. They are not produced in their affidavit any kind of.
No, the call records are produced.
But call records are only phone numbers. They show only phone numbers.
No.
It's not phone recording.
No recording is there.
So is there something to give further substance to what it is that you are accused of?
No. See, my dear friend, is it possible for me to impersonate Justice Vasifdar without at all calling? To say that I am Vasifdar, I must call. Their allegation is that I called Tambe and said I am Vasifdar here. I called from my mobile and said I am Vasifdar here. For that, to say that I must call. If I have not called, how can I say that? He called me.
So if he calls Mr. Nedumpara on his phone, then how do you say, no, this is not Nedumpara, this is Vasifdar? Why would you say that? How would one say that?
No, there is no such allegation.
Okay.
The allegation is
that you called him and said I am Vasifdar.
Yes, look at the judgment of Justice Rohington Nariman at paragraph, page number, yes. He has quoted, yes. So, the paragraph 9, where Justice Nariman has quoted the order of Chief Justice Mathews Shah. In view of the above affidavit, on 13 June 2013, after hearing the parties, this court directed the service providers, Vodafone Limited and Idea Center Limited, to produce on record of the call details of 3 cell numbers 98205-35428, 981-984-6333, 98205 35428 is mine. 981 984 6333 is that of my client Sanjeev Tejwani. And 810 8066 202, that is that of the Tambre, Dr. Saraf's client. For 4th March 2013 and 5th March 2013. On 5th of March 2013, I did not make a single call to anyone. That is, I'll show you all the cards. On 4th of March 2013, I made 6 calls. The 6 calls I made were, yes, this is the caller card which has been provided by the Vodafone, Mathews J Nedumpara, relationship Vodafone number. Yes, this is the date, outgoing cells. On 4/3/2013 at 10:53, I made a call to 981 984 688, that is Tejwani. Again at 10:56:31, again I made a call to Tejwani. Then at 10:58, I made a call 902 964 8281, that is to Adrian, my client. Then 9920 at 12:16, I made a call to Rohini, that is my associate, 99204 77447. Then at 141, I made a call to, yes, my client Tejwani. 2 calls, 141 and 155. Then at 2:12, I made a call to another client of my, Farwani. And at 12:26, I made a call to Tejwani's driver. And at 4:56, I made a further call to Adrian. On 6:50, you can see I did not call at all. Yeah. So I did not call at all. And the call records show that he has produced, the service provider has produced, show that he had called me twice.
Mr. Saraf, who?
Yes, Saraf's client. Saraf's client. This is the call. He had called me twice. Yes. Look here. Yes.
Okay.
Yes, these are the calls. This is 810-8066-202. 810-8066-202. These 2 calls
were initiated from his end.
Yes.
To you.
Yes. You can see this. These are the 2 calls made to me.
Okay. So what does the affidavit say? This affidavit says...
Affidavit, the Tambe filed a false affidavit. And the affidavit says... Yes, I'll take the affidavit. Yes. Give me 1 second. Yes, this is IAS Tambe. Yes. Assistant General Manager of General Kalyan Bank Limited. Yes. He says, yeah. I say that as per the appointment fixed on 4th March 2013 at 11 a.m., the said Special Recovery Officer had visited the said property for offering inspection thereof. And in fact, my client told me that they have come to take possession. I was on leave on the said day. At about 11:22 a.m., I received a phone call from a mobile number 98205 That is mine.
So this flies in the face of the facts,
yes.
which are
called. I am on receiving this call. To my utter shock and surprise, the person calling informed me as follows: I am Vasibdar here. Mathews is before me. Ask your advocate to call me. This is absolute perjury. He called me. I did not call, and the man who called me is saying that I had called and said this. I say that after hearing the said telephone call, I have informed Mr. Mohan Sheikh Rajak, who was at the site of receiving such call and information, and requested to take up the matter with our advocate to take proper note of the same. I, on subsequently attending the office, on verifying the records and papers and proceedings, it is revealed that the said mobile number belongs to the firm of advocates of the petition, namely Nedumpara and Nedumpara.
Oh. So he supposedly didn't even know that he is getting a call from you, and supposedly he didn't know whose number it was, and he was told it is from Justice Mathews.
There was absolute fabrication. I did not call at all. He did not receive any call from me. He called me.
And the call records.
And who made this affidavit to be filed?
Yes, who caused this affidavit?
This affidavit was made to be filed by Dr. Saraf. It was he who made this allegation in the open court and subsequently supported it. And why it was done? This was done only to defame me. See, I can understand allegations like, the Bobby, etc. Talking, all these allegations. This kind of allegations will not liquidate me. But an allegation of impersonation, that will liquidate me, finish me, because it's involving moral turpitude. You see, somebody
is there a connection? How is the writ petition is regarding something else? So is Mr. Saraf and these people, Mr. Tambe, are they relevant to this proceeding? Is there a connection? The contempt you in the course of the said proceedings, you named Mr. Fali Nariman.
Yes.
Let us say it is in the course of the said proceeding, so it's connected.
Yes.
Now this affidavit of Mr. Tambe on, let us say, on behalf of Mr. Saraf or whatever it is it connected in any way, or how does it connect with this proceeding in which you have been held in contempt? Is there a connection?
See, absolutely no connection.
There is no connection.
Unfortunately, all this was referred to.
So how do they become part of the same
I'm sorry, I have to be very careful and talk on the issue which is. But I am entitled to talk because even a man convicted has a right to plead that he is innocent. So I have even when I am convicted without not even an oral notice, without a charge sheet, without hearing me. I only came to know about the conviction from the social media in my absence, without notice, not even an oral notice, for a contempt in the face of the court. I am entitled, even a man who is convicted of murder, he is entitled to still say I am innocent.
And the public
and I say I am innocent. And these materials have nothing to do with the contempt in the face of the court. It's completely extraneous.
So how do they join
in law, even a conviction does not even constitute a prima facie evidence. And the Evidence Act says in a previous conviction or etc. is irrelevant fact. Suppose you face you face a criminal charge for say cheating. If your previous cheating is irrelevant. But the question is whether you cheated somebody on the particular case before it. The only issue which was there for the court to consider was whether I committed contempt in the face of the court, and whether my taking the name of Fali Nariman amounted to contempt on the face of the court. And that is erroneous. These things are absolutely erroneous.
So it is extraneous. This whole thing of this phone record.
It is unfortunate.
It is unfortunate. There is no connection.
It has nothing to do. And these are matters which are what kind of evidence it is. It is completely untrue, which I demonstrated.
So how does the Supreme Court pass an order?
These issues, the contempt of court, the court has only issued a mere notice. It is Mauritius order says yes. Since this court is only issuing a notice and not issuing a rule at this stage, no further observations are called for. So these are all matters, pending matters. It is nowhere decided, and even if it was decided, it is still amounting to. It doesn't amount to an evidence, even prima facie evidence, fundamental principles of law. Therefore, the problem with this.
So you've been convicted after
this judgment has been, directed to be it's a reportable judgment, so it will come in the law journals, and since a lawyer is involved, lot of lawyers and the public will read it, and therefore, see, when they read all these things, they will certainly form a very bad opinion about me. And I'm not saying that the court has referred to all this to paint me in the dark. I am not saying that. I don't intend. I will always. Judges always act bona fide. But see, I told you the fundamental principle. Even if I have no right to say a judge would ever act without bona fide. The first principle of jurisprudence is de faido officio judicis non recipit quaestio. About the integrity, honesty of a judge, no questions are received, no question can be asked. De faido officio judicis non recipit quaestio. But de sentia, about his knowledge. Save juris, save facti, about his knowledge and his correctness of what his decision on facts and law can always be questioned. So I don't.
How did he get the knowledge of this?
No, I won't go into any of those things. I will only say that the judge did not intend to do any harm to me, and it would have been the wildest of in the dreams. Certainly the judge did not intend to do any harm to me. His lordship referred to it. His lordship ought not to have referred to it. But the effect is, by referring to it, the report being, the judgment being published in live laws, bar and bench, and it is going to be reported. Thousands and thousands of people have read it, and whoever read this principle, whoever had read this judgment would think, see, Mathews Nedumpara is such a rascal who goes to the extent of impersonating a judge. Whereas what is the truth? You have seen it. I did not even call at all.
Your writ petition fell by the wayside in all this. What is the judgment saying about your writ petition? Like, that is since the judgment...
So, the judgment unfortunately has not delved into the merits of the...
How many pages? How many
pages?
No,
I will not go into those issues.
But what happened to the writ petition? It's dismissed?
It is dismissed, yes. The point is, writ petition, the focus of the writ petition is that the designation system brings, it has a pernicious effect on the interest of the poor litigant. And the third petitioner is Sunil Gupta, is the office bearer of the campaign for Home for All. And why I say is that I have showed you before that in a case where 5 senior lawyers appear for the state, for the central government, for the other Janhidman and all, which directed all slums in mangroves to be demolished, and thousands and thousands of slumlanders were rendered homeless brutally. In Colaba, 3,000 families were 3,000 homes were demolished, and I couldn't do anything because I was not in station. And that they were leaving their shanties for last 30-40 years. And all this because the senior lawyers, they never think, with utmost respect to them, because they live in such a comfort and in the situation, they don't think of the poor. So who thinks of the poor? Many of my colleagues are from humble backgrounds. I have lawyers who are in the slum dwellers. Many. The National Lawyers Campaign has no celebrity lawyers. Our voice have little value. Our cries are in the wilderness. This organization represents the underdogs, small lawyers who have no financial wherewithal and who suffer all sorts of injustice and discrimination and suffering.
So this writ petition has fallen by the wayside and cannot be pleaded again?
See, there is nothing like there is first principle is there is no res judicata, no estoppel against law. There is nothing. There is no estoppel against law. It's only issue. Suppose a court has decided the issue. If you come up with the same issues in an immediate future, then naturally we are all judges are human. Everybody is human. Then certainly there will be some kind of a difficulty to accept such a plea. So we have to wait for some time.
An obstacle.
Human nature. Suppose this issue has been decided today. Tomorrow I file a petition. Certainly courts will be reluctant to accept it, and people will say, "Are you mad? Why this issue was decided yesterday?" So we have to wait. We have to wait for these issues to be re-agitated.
Okay.
So these reforms will continue. National Lawyers Campaign will continue its reforms, judicial reforms, and the first and foremost is, now this incident says, my first and foremost is the focus on video recording of court proceedings. If I am an indisciplined lawyer, somebody who bribes the judges and all and misbehaves in the court, then videos will disclose it. I'll be nailed. So therefore, the video recording brings you absolute transparency, absolute fairness, and I'm sure this video recording, the court proceedings will become a reality. And I have filed a petition recently, and I believe it will be listed. Thank you.
Thank you so much, sir.
Yeah.
Thank you very much for speaking to us.
It was nice.